To debate House Bill 171. This time I'd like to call upon the senator from the 45th to speak to the bill. Chair recognizes the senator from the 45th to speak to the measure. The Senate is coming back to order. The chair would like to recognize the senator from the 45th to talk to the bill, speak to the bill.
Thank you, Mr. President. I hope everyone had a good lunch this afternoon. We appreciate being given the opportunity to have a lunch today. We didn't have a lunch yesterday, and we were a little bit hangry. We were hungry and we were angry, and it lasted the whole day. But anyway, thank you very much. I rise, and I appreciate the senator from the 29th bringing this bill forward, but I have a lot of reservations about the bill. And I, like him, am not a part of the Legal Eagle Caucus. I drove by that law school, too. As a matter of fact, I was at the University of Georgia, and I was in the School of Social Work, and I used to walk by the law building, but nothing in that law building went in my brain, unfortunately. But I do have great respect for the members of our Senate body that are attorneys, and I do have reservations about this bill because it could not get through the Judiciary Committee. And for that reason, it went to the Public Safety Committee, and I'm not disparagingly talking about the Public Safety Committee, but I do have a lot of respect for the attorneys in here, and I ask them for a lot of advice a lot of times. Sometimes I take it, sometimes I don't take it. But on this particular bill, it is very technically oriented. And the reason I rise in opposition to it is because of one person. One person. And when I look back on my career here at the Gold Dome, and I look at all the things that influenced me and all the things that happened, unfortunately, one of the issues and one of the ceremonies that stood out to me the most was a ceremony that we had downstairs on the South Wing, and it was by the Women's Caucus, and it was a joint ceremony between the House and the Senate Women's Caucus, and unfortunately, it was at the beginning, I think 3 years ago, and there was a terrible incident that happened on I-16. 6 nurses that were in school at Georgia Southern were in an accident. They loaded up in the morning about 5 o'clock in the morning, as I recall. They got in the car. They were going to their last day of nursing practicum. Last day. They were on I-16. It was early in the morning, of course. They probably had to be on the floor at 7 o'clock in the morning at a hospital in Savannah. They were in a car, and as I understand it, a row of cars stopped, and they stopped also. And there was cars stopped behind them. But unfortunately, an 18-wheeler ran into the back of them. And the reason I'm standing here today is for those 6 nursing students. And I can tell you, it's few and far votes that I have ever voted with the Georgia Trial Attorneys Association, GTLA. Very few times. But when it comes to the consumer, it comes to the person, the little guy. And this is the little guy that I'm talking about, these 6 nurses. When it comes to them, when you're talking about those scales of justice and who is playing evenly and who is being treated evenly, and you're telling me those 6 nurses don't have a fair play in court, that I'm telling you I will stand up for them. And I don't care who's in the hall, and I don't care who's lobbying me. And we've seen the list lobbying on both sides of this. I could care less. And I could care less that I can't stand up here and argue with the attorneys in this room. But I can argue about what's right and what's wrong and what's in your heart. And I know that this is in my heart. And I want to tell you about these girls. There was 6 of them. Emily Clark was 20 years old from Powder Springs. Morgan Bass was 20 years old from Leesburg, Georgia. Abby Deloach. Everyone knows the Deloach name here in the state of Georgia. It's a very political, well-known, well-connected family name, the Deloach family from Savannah. Abby was 21 years old. Catherine McKay Pittman was 21 years old from Alpharetta, Georgia. And Caitlin Baggett was 21 years old from Millen, Georgia. The girl that I'm standing up for today, her name is Megan. Megan Richards. She's the lone survivor. She suffered traumatic brain injury. She said she was the lucky one. She survived. And this is the quote from her newspaper article. I stay hopeful. I'm a Christian, and I believe that maybe I did live for a reason, and he'll help me make a big difference as a nurse. But sometimes I can't help but think about how it changed me and how hard it will be. Her 5 best friends died in that accident. They never graduated from school. They never became a nurse. They never got to try and save other people's lives. Megan is now a pediatric nurse at a Savannah hospital. She still struggles with PTSD. Like I said, she had traumatic brain injury. She had multiple other injuries. But that's why I'm here today. The man that ran into them on April 25th and was a Louisiana truck driver. His name was John Wayne Johnson, and he was driving the 18-wheeler. Johnson pled guilty for 5 counts of first-degree vehicular homicide plus other charges. Mr. Johnson would serve 5 years in prison and 5 years on probation on a plea deal. Megan's still with us. Megan emailed me this morning, said of all the things you do, make this fair. She was in the rear seat with her friend. At the moment of impact, she did not have on her seatbelt. I do not know why she did not have on that seatbelt. But should Megan be punished because she didn't have that seatbelt on? My answer is absolutely not. Should she not have the ability to take care of those damages, those personal injury damages of someone who has traumatic brain injury? You better believe she should. What about all the people that end up on a ventilator? What about all the people that end up for the rest of their life in a vegetative state? Shouldn't they have the ability to get that income to be able to support them? I say yes, because I've taken care of them, Everyone in here knows the high cost of health care. There is no way that you could deny them. So on behalf of Megan, I'm here standing for her. And I know it's hard, and I know I can't defend this bill and answer all the lawyer questions, but I can answer the question of knowing what's right and what's wrong. If this bill would have been a good bill, it should have gone through the Judiciary Committee with all the attorneys that can answer these questions. But it didn't. It circumvented. It got added to another bill. I say let it be a standalone bill. Let's let the other bill go through. I support the amendment that the senator from the 3rd wrote, but I do not believe that this should go through as the way it is. I do not believe when you're talking about those weights of justice that I think that little person that we're sent here to represent, I think that is the person that we need to stand up for. So with that, Mr. President, I'll be glad to answer any questions. I will say that it's a sad occasion when we remember those nurses. And I don't want any of those parents that are watching this video to think that we don't hold them in reverence, and to know that we learned when that happened to them that we don't forget. We don't forget what happened to them. It's etched permanently in my mind. Every time I think about I'm having a bad day, I think about those nurses' families, and I know that I'm having a good day. That's not a good club to be in when you have a child to pass away and then you live with it the rest of your life. So if there's anything I can do, I'm here to do it for them. So with that, I'll be glad to answer any questions, Mr. President. I think everyone's back from lunch.
Chair recognizes the senator from the 17th for a question.
Thank you, Mr. President. Does Senator yield?
Yes, sir.
Senator, isn't it true the number one reason people file bankruptcy is outstanding medical bills?
Unfortunately, that is becoming more and more common, and that was what I was talking about. When you're in these severe accidents and have long-term injuries, that you just don't go to the hospital and get well, and you certainly don't go to the hospital and be able to pay your bills that are mounting, that are over $100,000 or however much they are. Those bills are insurmountable, and unfortunately, it's not just the person that's injured, it's the families that have medical bankruptcy. And yes, sir, that is a huge, huge issue, and we've talked about that here in the Senate many, many times.
Do you further yield?
Yes.
Senator, isn't it true that if this bill passes without amendment number 1, someone that's injured in an accident through no fault of their own, instead of going to try to seek to have those medical bills paid, the first thing they'll have to do is go pay to have an expert hired to argue in court whether or not they had their seatbelt on and how that may or may not have impacted their injuries. Isn't that true?
That's exactly right. And can you imagine being in that situation where you have 5 of your best friends to pass away, and then you're having to worry about the grieving process that you're going through, and then have attorneys and hiring expert witnesses? I can't imagine the compound of that process and trying to survive it. I can't imagine.
You have no more questions.
Thank you. I yield the will. I ask for your favorable consideration on amendment number 1, but I also ask that, unfortunately, we have to disagree on House Bill 171 and not be in favor of it. Thank you very much. I yield the will.
There's an amendment number 2 that has just arrived. Would like amendment number 2 to be read, Mr. Secretary?
Amendment number 2 by Senator Stone of the 23rd and others offers the following amendment to House Bill 171's committee substitute. On line 30, following the symbol period and before the word violation, insert the following. If evidence of a person's violation of this code section is introduced into evidence by an adverse party in the person's civil action and that adverse party was given a citation for other purposes. Mr. President, that concludes the order.
Chair would like to recognize the senator from the 23rd to speak to his amendment.
Thank you, Mr. President, colleagues. First of all, I do want to tell you that I oppose the bill. I gave a hearing to this bill in Judiciary and look forward to trying to perfect it over the next year. We didn't see any rush or any need to have it passed out immediately. One of the things we hadn't heard from was the State Bar. You know, we attorneys on the Judiciary Committee don't practice in every field, but we have an organization of thousands that stand behind us who can weigh in and help us make the right decisions. That hasn't happened yet. If we pass this unamended, we will be legislating on the fly, and usually the outcome of that is not very good. It took 10 years to perfect the evidence code. Work began on it when then Senator Deal was chairman of the Judiciary. I don't think we can do this right overnight. But if this is a path that you choose to go down, then I've offered an amendment. This Amendment 2 is not necessary if Amendment 1 passes and the bill goes back to its original form. But if that amendment does not pass, then all this does is allow evidence of any citations that are issued incidental to the accident. And I guess it boils down to this. If we're going to let it all hang out, what's good for the goose is good for the gander. And I think that would be a matter of fundamental fairness, of balancing, even though we haven't had time to adequately vet the bill. So if you don't vote in favor of Amendment 1, please vote for Amendment 2. If Amendment 1 passes, I will, of course, withdraw Amendment 2. Mr. President, with that, I'll yield for questions.
Chair recognizes the senator from the 42nd for a question.
Thank you, Mr. President. Will the gentleman yield?
Yes.
Senator, I was going to ask this of the senator from the 45th, but as a learned attorney, I think you'll be able to answer it. With the case, with the very sad case of the nursing students,
Right.
it's my understanding, as the senator from the 45th mentioned, that the lone survivor was in the back seat and not wearing a seatbelt. And isn't it true that it is actually not current Georgia law that the passengers in the back seat must wear a seatbelt?
I think the senator knows of what she speaks. Would add to this, if this was a matter of public safety, we wouldn't be talking about rules of evidence. We'd be talking about fines, making a $15 fine, a $1,000 fine, taking steps along that direction. But we are here trying to decide the rules of evidence. Who is at fault in an accident? Of course, it's the negligent driver who causes the accident. But this evidence will confuse juries, I predict. So, again, I don't think it's a path we need to go down.
Thank you, Senator.
Thank you.
Chair recognizes the senator from the 48th for a question.
Thank you, Mr. President. Does the chairman yield?
Yes.
Isn't it true that under current Georgia law that unless a defendant is found 50 plus 1% or more responsible for the accident, the plaintiff gets zero?
I would defer to your judgment on that. Let me just tell you, I told you we're not all experts in this area, and I confess I've done plaintiff's cases, I've done defense cases, but that's not the majority of what I do, and I don't want to make the wrong answer to that question, so I defer to your judgment.
And does the chairman further yield?
Yes.
And I believe it would also be true if it were a 50-50 case, that the nurses, as spoken about the senator from the 45th, would receive nothing under this new law.
I think you're right.
Thank you, sir.
Thank you.
Chair recognizes the senator from the 45th with a question.
Mr. Chairman, would you please yield?
Yes.
Mr. Chairman, I think you are correct, and probably when I was up there, I was so emotional about these nurses. But it is true that lone survivor, that sixth person, would have received zero, absolutely zero, if this law were in effect. Is that not true?
That's incredible. And some of those victims were constituents of mine.
You have no more questions.
I urge you to vote in favor of Amendment 1, but if you do not vote for Amendment 1, vote for Amendment 2. If you don't vote for that, vote against the bill. Thank you.
Chair recognizes the senator from the 42nd to speak to the bill.
Thank you, Mr. President. Colleagues, part of our job as policymakers is to take into account varying interests on all sides and try to come to a good balance in public policy. It's really the same thing that the court system is set up to do. And what we have, as some other learned senators have already put forth from the well, is a situation where we haven't been able to ask all the questions and get all of the information and really thoroughly go through the legislative process to ensure that a change of policy of this magnitude is properly balanced. And here are just a couple of the issues that I wanted to bring forward. First of all, we've heard some talk about how other states do it. It's my understanding, and I believe it was elicited through some questions asked by the senator from the 6th, when the sponsor was presenting the legislation, that of the states which are less than a majority, I think it's about 20, that allow this lack of usage of a seatbelt into evidence, the majority of those do it in some sort of limited fashion, where maybe a portion of the damages would be discounted. So I have questions as an attorney about what are the various ways that this policy could be crafted to have balance and fairness so that we don't unduly disrupt the scales of justice. We have questions about what other forms of evidence in cases such as these are or are not allowed into evidence. And that goes to what the senator from the 23rd was mentioning with his amendment. If we're going to allow this evidence that currently is not admitted into these cases we should have a thorough conversation about what other forms of evidence our law currently designates as unduly prejudicial to a jury in cases like this, and decide, do we need to incorporate some of that, as the senator from the 23rd was saying, to make sure that our scales of justice, that we have not inadvertently tilted them too far in the other direction. I have a question about leverage in these cases. I believe that it would be possible to have a thorough discussion that took into account aspects of what the proponents of this legislation believe in and are putting forward. But another question is that I would like more information on is, in cases like this, when you've got a lot of insurance companies involved, what are the relative points of leverage between plaintiffs and defendants? I would want to ensure that we aren't creating too much of an obstacle to the courthouse door if there are plaintiffs that are individuals versus, large insurers or large companies. And that's something that, again, it is our duty to try to craft a balanced public policy around. Also, I raised the issue that, in the tragic story of the nurses, and I was at that Women's Caucus memorial service spearheaded by the senator from the 45th and others in the Women's Caucus, and also the families of some of those victims came down many times last year to exhort us to pass the distracted driving bill. So they have stayed involved, and it is a tragic case. one of the things that I think I wanted to put a finer point on is that Megan, who I believe was in the back seat and not wearing a seatbelt, that is not illegal under Georgia law to not wear a seatbelt in the back seat. Whether or not it should be, I don't want to speak to you right now. I certainly believe that everyone should wear a seatbelt and that we should have public policies encouraging that. The problem that we face right now is if someone is doing something that is not actually against the law, and then that would still be admitted into evidence, then they would be totally prejudiced and unable to recover in their case for something that we haven't even said they shouldn't do. So that's a real problem. That's another big question I have about this, and it goes to the need for further vetting and further discussion and analysis by those that understand these cases, those that practice in this area, to ensure that we have not thrown too far off the scales of justice, to ensure that when we do take action related to seatbelts, we do it in a context where every party can be treated fairly. Because it didn't go through judiciary, we have not had the opportunity to do that. I, too, have only the greatest respect for our colleagues on public safety. But when it came to the Judiciary Committee, this has long been a policy that's been under discussion here at the Georgia General Assembly. As a matter of fact, I attended a Judiciary Committee meeting in the Senate in 2009 when I was an aide to a senator, a predecessor of mine in this very seat, who was on Judiciary, and there was a hearing on this very bill. So I know that it's been down here for a long time. So I said to myself, well, as a member of the Judiciary Committee, it is incumbent upon me to become more familiar with the laws and the pros and cons surrounding this policy right here in our state. So even though I am not on the subcommittee that heard the hearing when the senator from the 29th did bring his original bill forward, I attended anyway because I really wanted to do my work to be a reasonable voice throughout this policy and try to weigh in on crafting a balanced public policy. So, I never got that opportunity. So I have to oppose this for all the reasons I stated, including the fact that it just wasn't vetted in the sense that we ensure that the public policy remains fair for all Georgians. And for that reason, I'll be voting no today. I will be supporting the Center from the Third Amendment and the Center from the 23rd Amendment if the First Amendment fails. But I am, Mr. President, happy to answer some questions before I take my seat.
You have a question. The chair recognizes the senator from the 45th.
Would the senator yield?
Yes, of course.
Senator, you stated that you were an aide in 2009.
Yes, ma'am.
When I was in this body.
Yes, you were.
I remember that. I remember that well. Wouldn't you agree that if an issue had been around here for a decade now, for 10 years now, that if it had validity and if it had goodness in it, and it was helping the citizens of Georgia, that within a decade, then it would have passed?
Well, I think you're exactly right, Senator, and I have made that point to some of my friends that in the Chamber of Commerce and companies who are supporting making this change. And I have told them how I was here in 2009, and because it's one of those things that's easy to misunderstand until you really drill down. Because as a sort of common sense thing, your first instinct might be, well, of course that should be allowed. And so when you get into the details, that's when you see why the decision was made all those years ago to not allow this into evidence, and why, if we are going to allow it into evidence, there are other very valid questions about the scales of justice that then need to be a part of that conversation. Thank you for the question, Senator.
You have no more questions.
Thank you, Mr. President. I yield the well.
Chair would like to recognize the senator from the 29th to close debate.
Thank you, Mr. President. Surprisingly, I oppose all amendments. But I'll be honest with you. I feel like I was quail hunting. I was walking down a trail, walked around a corner, and instead of a bunch of covey of quail come up, it was red herrings. And every one of them had a law degree in their hand, flying away. We talk about how long it takes to get legislation down here. I can think of a piece of legislation that's really good, and it took a long time to get passed. And it was passed finally by a gentleman yielding over in the House. And it was about wearing seat belts. Every year, somebody would come back with seat belts. And eventually, the speaker over there yielded and let it get passed. And it has saved thousands and thousands of lives. Some of my closest friends worked on the case that the senator from the 45th spoke about down in South Georgia. They represented the families, and they worked hard on it. Nobody has stood up here and said that some party that is wrong does not deserve to be made whole, or as whole as they could possibly be after losing a loved one. But the point is, it's proportion. The young lady who was in the back seat that was not wearing a seatbelt was not required to wear a seatbelt under Georgia law. So that evidence had nothing to do with what we're talking about here. Somebody got up here and spoke about fancy vehicles with black boxes. I hate to tell you, but if you go get a car off the car lot, and it's the least expensive vehicle they have, it's got a black box in it. And the tool that it takes to get that information off of it is about a $4,000 tool. Each individual cable for each individual vehicle is $150. And to hire an expert that, and listen, I'm an expert witness in cases pertaining to public safety, and people like to throw out the expert word. The expert is somebody who can download off that equipment when you're talking about the information in the vehicle, being in a report, and being involved. But bottom line is this. You heard what needs to be done. You heard it from a firefighter. You heard it from an attorney that supports it. And then you heard it from a lot of attorneys that don't. And listen, I haven't heard from the Peace Officer Standards and Training Council either, and they represent the 60,000 law enforcement officers in this state, but I know where they stand on this. And emotion in this gets injected into this argument sometime, and I appreciate the fact that somebody wants to come up and tell about a personal, heart-breaking circumstance, but I'm going to tell you, until you've walked around in the kudzu in the middle of the night looking for somebody thrown from a vehicle who you know there's absolutely no way they could have survived, or until you remove a child from a car with a closed head injury because her mother didn't want to put her in a seatbelt but was more concerned about the sign on the door of the vehicle that struck their car than the health care of her daughter, please don't be offended by my emotion. And just because a group of my colleagues who I respect a lot and who know more about law than I will never know as long as I live, get up here and tell you something's bad, I can promise you there's not a piece of legislation that's going through this General Assembly this year, this session, that somebody in here will tell you is bad legislation. So all you have to do is dig down, do what's right, help justice be fair to everybody, vote down these amendments, and if you want to talk about fair and balanced, give it to everybody. Because all the people you're talking about, they're not the public safety officers out there doing the job. They're not the businesses that make Georgia the best place in this country to do business, that every time one of their vehicles leaves a parking lot, there are individuals who are sitting at home right now watching commercials about every cotton-picking law firm in the world that wants to get them a quick settlement, that they don't see those UPS trucks, they don't see those other vehicles as lottery tickets. Those are the cold, hard facts. There's no emotion involved. It's reality. And as a state senator, my job is to come up here, stand on the hill, and take the heat straight on. And if you vote for me, thank you. And if you vote against me, thank you. I appreciate your service. Mr. President, I yield the well.
Thank you, Senator. At this time, we're going to start to take up the amendments. All right, we are by Senate rule, we're going to take up amendment number 2 first, because amendment number 1 would strike the language that amendment number 2 would address. And so we will take up amendment number 2. Would the two, 2 amendment authors, would the 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 2 amend For what purpose does the senator from the 23rd rise?
Mr. President, I'd like to withdraw amendment number 2.
Senator from the 23rd has moved that amendment number 2 be withdrawn. Is there objection? There's no objection. And amendment number 2 is withdrawn. For what purpose does the senator from the 29th rise?
Mr. President, I move for the brain freeze. Previous question.
All right, we will vote on the previous question. For what purpose does the senator from the 45th rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, I don't know what was said up there, but I do know that these amendments were on our desk. In the previous question, these amendments were included on our desk. You're going to vote on the amendments?
The senator from the 23rd has withdrawn his amendment.
Right.
The previous question will bring us to a vote on amendment number 1.
Okay.
If successful, amendment number 1, and then the
Okay.
overlying measure.
Thank you very much.
All right, we will vote on the previous question. All those in favor of the motion. For what purpose does the senator from the 41st rise?
Parliament inquiry,
State your
Mr.
inquiry.
Is it not true that we would, if the previous question hadn't been moved, that we would probably move along and had this bill already voted on, but we should defeat the previous question to allow us to properly act on this bill?
It's for each and every member to decide on their own. All those in favor of the motion will vote yea, opposed nay. The secretary will unlock the machine. For what purpose does the senator from the 45th rise?
Parliamentary inquiry.
State your inquiry.
Is it not true, Mr. President, that we are asking for a red vote to not move the previous question? A red button, please.
Each and every member to decide. Chair recognizes the senator from the 19th.
President, parliamentary inquiry.
State your inquiry.
Is the point of the motion for the previous question voting it down to allow the senator from the 23rd to reintroduce his amendment?
The gentleman knows of what he speaks. Chair recognizes the senator from the 29th. He waves. On the motion, the yeas are 20, the nays are 27, and the motion has failed. We will now take up amendment number 1. The question is on the adoption of amendment number 1. Is there objection to adoption of the amendment? There's objection. For what purpose is the senator from the 45th rise? She waves. All those in favor of the amendment from the senator from the 3rd will vote yea, opposed nay. The secretary will unlock the machine. For what purpose is the senator from the 45th rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that we're asking for a green button on amendment number 1, a green button?
Each and every member to decide. Chair recognizes senator from Roswell.
Thank you, Mr. President. Isn't it true we're asking for a red vote to support businesses in Georgia so we continue to be the #1 place to do business and support our public safety?
Each and every member to decide on their own. Chair recognizes the senator from the 42nd.
Parliamentary inquiry.
State your inquiry.
Mr. President, isn't it true that since we've been the #1 state to do business for a number of years running, that clearly this law has not impeded our business success?
The senator speaks with great passion. On the adoption of the amendment, the yeas are 24, the nays are 23, and the amendment is adopted. For what purpose does Senator from the 29th rise?
Parliamentary call for reconsideration.
Is there objection? There's objection. The motion now is to reconsider. The motion is to now reconsider to vote on amendment number 1. All those in favor, vote yea, opposed nay, and the secretary will unlock the machine on amendment number 1. Voting on reconsideration. For what purpose does Senator from the 45th rise?
Is it not true, Mr. President, that we need a red vote on reconsideration? A red vote on reconsideration. The vote was 24-23. Red vote.
On the motion to reconsider, the yeas are 26 and nays are 23. The motion prevails, and the Senate will reconsider House Bill 171, Amendment number 1. Amendment number 1. All right, let's take up Amendment number 1 one more time. For what purpose does Senator from the 19th rise?
Parliamentary inquiry,
State your inquiry.
Mr. President, would someone please, would the Secretary of the Senate please give us the timing on the reconsideration, given that today's day 37?
Secretary has advised that on any amendment, it's immediate, regardless of the day. All right, we will now take up Amendment number 1. The question is on Amendment number 1. All those in favor of Amendment number 1 from the Senator from the 3rd will vote yea, opposed nay, and the Secretary will unlock the machine. What purpose does Senator from the 45th rise?
Is it not true, Mr. President, if you voted green before, you need to vote green again? We need the green votes. Is that not true?
I'm certain the senator knows of what she speaks.
Is it not true, Mr. President, standing up for the victims of Georgia? Is that not true?
Senator speaks with great passion. On the adoption of the amendment, the yeas are 24, the nays are 25, and the amendment is lost. State Chair recognizes the Senator from the 48th.
Motion to reconsider.
That motion's out of order. You cannot reconsider twice. For what purpose does the senator from the 23rd rise?
Mr. President, I refiled Amendment 2.
For what purpose does the senator from the 29th rise? He waves. For what purpose does the senator from the 45th rise?
Mr. President, is it not true in this body that we have had reconsideration for 3 times in this body before? 3 times we've reconsidered votes.
Senate will come back to order. Senators, please take your seats. Senators, please take your seats and cease all audible conversations. I'd like to call on the Secretary to read what is now Amendment Number 3.
Amendment number 3 by Senator Stone of the 23rd offers the following amendment to House Bill 171 Committee Substitute on line 30, following the symbol period and before the word violation. Insert the following. If evidence of a person's violation of this code section is introduced into evidence by an adverse party in the person's civil action, that adverse party was given a citation for a violation of any provision of this title in connection with an incident giving rise to the civil action, that adverse party's citation and any judicial determination regarding that citation shall be admissible in the civil action on the issues of fault, negligent, causation, liability, and damages. And on line 77 following the symbol period, insert the following. If evidence of a person's violation of this code section is introduced into evidence by an adverse party in the person's civil action, and that adverse party was given a citation for a violation of any provision of this title in connection with an incident giving rise to the civil action, that adverse party's citation and any judicial determination regarding that citation shall be admissible in the civil action on the issues of fault, negligence, causation, liability, and damages. That concludes the order.
Senators, please take your seats. We've been at this for hours. It's time to close debate and to move on with the calendar. We will now take up Amendment Number 3. I'd like to recognize the senator from the 23rd to speak to his amendment.
Amendment number 3 is Amendment number 2, the one that I originally introduced and then withdrew. It was withdrawn because there was a ruling that it had to be considered before Amendment 1. So all this does, if you want to allow all evidence of violations related to an accident in, this does it. It doesn't just allow evidence of non-wearing of seat belts. Any other citations or violations would also go to the jury. So if we want to open up the evidence, make it fair to all parties, this is the way to do it. Be happy to answer any questions.
Chair recognizes the senator from the 46th for a question.
Senator Yield,
Yes.
is this what you would deem the classic definition of a poison pill in legislation, to totally upend
Not at
the
all.
civil justice system in order to kill the underlying bill?
Not at all. This is an amendment I intend to support, and I would think that other people on the opposite side of the Capitol would support it as well, rather than having a one-sided view of it, the rules of evidence.
Chair recognizes the senator from the 47th for a question.
Thank you, Mr. President. Would the senator yield?
Yes.
So in an accident, this would give an example of say somebody has bald tires, improper, no headlights, something like that. All that would be admissible in court.
Right. It would all be relevant for the jury to consider.
Thank you.
Thank you.
Chair recognizes the senator from the 48th for a question.
Thank you, Mr. President. Does the chairman yield?
Yes.
Isn't it true that under your amendment now, if the person the defendant who's hit the mom has a DUI conviction, that would now come into evidence, so
Yeah.
it would be more fair?
That's correct.
Thank you, sir.
Thank you.
You have no more questions.
Thank you.
The question is on the adoption of the amendment. Is there objection to the adoption of the amendment? Hearing no objection, there is objection. Was waiting for that. All those in favor of the amendment from the senator from the 23rd will vote yea. Opposed, nay. The secretary will unlock the machine. For what purpose the senator from the 45th rise?
Parliamentary
State your
inquiry.
inquiry.
Is it not true that's a red herring by saying this is a poison pill and we're asking for a green vote? Is that not true?
Each and every member to decide on their own. For what purpose the senator from the 29th rise?
Parliamentary inquiry.
State your inquiry.
Am I the only person in this room that can identify a red herring?
That is definitely up to each and every member. On the adoption of the amendment, the yeas are 30, the nays are 24, and the amendment is adopted. In reference to a couple of questions that were asked earlier about reconsideration in Mason's legislative manual, section 457, paragraph 2, to prevent abuse of the motion to reconsider, the same question cannot be reconsidered a second time. The question is now on the adoption of the committee substitute as amended. Is there objection to the adoption? For what purpose the senator from the 48th rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true that the addition of the language from lines 22 all the way through 60, all the way to 80 into the bill violates the Constitution, Article 3, Section 5, Paragraph 3, and therefore should not be considered?
It's the ruling of the chair that's up to each and every member to decide on their own. The question is now on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute is adopted as amended. Is there objection or agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass by substitute? The questions on the passage of the bill by substitute. All those in favor vote yea, opposed nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 27, the nays are 28. This bill has failed the requisite constitutional majority and therefore is lost. Chair recognizes the senator from the 29th.
Move for reconsideration.
The senator from the 29th has served notice for reconsideration on the next legislative day. Been waiting to say these words for a while. Mr. Secretary, can you read the caption to House Bill 213?
House Bill 213 by Representative Corbett of the 174th and others. A bill be titled Enactment Title II of the OCGA relating to agriculture so as to enact the Georgia Hemp Farming Act to provide for unlawfulness of certain actions, to authorize certain academic research of hemp, to provide for licensing and permit requirements for hemp growers and hemp processors, respectively, to provide for the Department of Agriculture to enter into agreements regarding such testing and other matters, to amend Part 1 of Article 2 of Chapter 13, Title 16 of the OCGA, relating to schedules, offenses, and penalties regarding regulation of controlled substances so as to revise the definition of the term marijuana, to provide an exception to the scheduling of tetrahydrocannabinol and tetrahydrocannabinolic acid as controlled substances and for other purposes. Mr. President, Senate Committee on Agriculture and Consumer Affairs offers following substitute House Bill 213, a bill will be titled Act to amend Title II of the OCGA relating to agriculture so as to enact the Georgia Hemp Farming Act, to provide for legislative intent, to provide for definition, to provide for unlawfulness of certain acts, and for other purposes. Amendment 1 by Senator Karen Shack of the 48th offers the following amendment to amend the Senate Committee substitute to House Bill 213 on lines 114 through 115 strike, shall be a qualified agricultural producer as defined in Code Section 48.8.3.3 and Amendment 2 by Senator Rockman of the 5th offers the following amend the Senate Committee substitute to House Bill 213 by striking misdemeanor on line 171 and replacing it with felony. Mr. President, that concludes the order.
Chair recognizes the senator from the 7th to speak to House Bill 213.
Thank you, Mr. President. After that lively debate, I think I finally got something to bring before this body we can all agree on. Because after that debate, we might need a little hemp, and that's what we're going to try to do, Mr. President, with this little bill that's sitting in front of you. Ladies and gentlemen, the Senate, House Bill 213 is a bill that would establish Georgia's place in regards to hemp farming in our state. Many of you may or may not be aware, but in 2014 there was the federal government or the Congress passed the Farm Bill, which included provisions for pilot studies for hemp being grown across the country. And then again in 2018, just recently signed Farm Bill back in December, signed by the President. In that Farm Bill, industrial hemp was no longer included on the federal controlled substances list. And it explicitly allows states to create plans to grow hemp in each individual state and submit those plans to the United States Department of Agriculture. I will say this, in that also in the Farm Bill, it provides that if a state does not opt into a regulatory program, the USDA will then create a structure under which hemp will be cultivated in those states. And then they would comply with the federally run program. So I think it's in our best interest for us to establish a program that will be Georgia specific, and that's what we're trying to do. 41 states have already passed legislation related to hemp, and 39 states have already allowed for cultivation and production within their state. So Georgia we're just trying to come up to speed with where a lot of our partners are across the country in regards to this. So what does 213 do? Basically, it establishes the framework to allow for licensing of both growers and processors. It promotes cultivation and processing of hemp in our state, and it would encourage and empower research into growing hemp and allow farmers and businesses to cultivate, handle, and process and sell hemp products for commercial use. There are a number of provisions in the bill dealing with law enforcement's ability to come on the farm property to make sure that you are only growing hemp. Hemp is defined federally by 0.3% THC or less, and there are provisions in the bill that if you're over that limit, that the crop would either have to be destroyed or the product would have to be destroyed. Obviously, all hemp grown is subject to testing. All producers will have to sign an agreement to that particular case. And any violation of the rules or regulations under here, that individual will be subject to being submitted to the Attorney General and the U.S. Attorney General. Inadvertent violations obviously would be dealt with through the Department of Agriculture. So we believe we've put some pretty stringent language on this to make sure that this is a controlled process in our state, but at the same time a new industry that we can grow in Georgia and be able to prosper from as a state, and also be in a state that is the number one state in which to do in which to do business, but the number one state in agriculture as well, that being our number one industry. We think that would be this is a great opportunity for us to grow that industry in Georgia. The bill also further directs the Commissioner of Agriculture, along with the governor and others, to submit a plan to USDA for their approval. And obviously this would not go into effect until USDA approves such plan. However, we in the legislation, we have directed and allowed our university system, our land-grant institutions, and those institutions which can do studies on agricultural products to go ahead and start studying and providing for research in regards to this issue upon the signature of the governor. So they will not have to wait on our plan to come back from USDA. That is a brief overview, Mr. President, of the bill. I'd be happy to answer any specific questions. I will speak to the amendments very briefly, really quick, before we get to questions. Amendment 1, I will ask your consideration on a opposing.
Senator, please stand at ease for a minute.
I'll stand at ease, yes, sir.
The Senate will come back to order. Each and every senator deserves the respect in the well. Thank you. Go ahead and proceed.
In regards to the amendments, Mr. President, I would ask that this body oppose amendment number 1. We are trying to encourage growth among our producers and our farmers in our state. This amendment would strip that language out of the bill and allowing those across our state that have toiled long and hard to continue to be producers of this product. And I would appreciate your consideration in opposing that amendment, because we believe those are the individuals who have the understanding and the knowledge to be able to grow products in our state, and we think that they should continue to do that. Amendment number 2, and I appreciate the senator from the 5th and his understanding of current Georgia law, but I will say that I will also be opposing the Second Amendment for this reason. Although in Georgia we may or may not have laws on the books related to misdemeanors of selling or trafficking of drugs in our state, there are laws in other states that there are misdemeanors on selling and trafficking of other products. So if you are charged with that particular crime in another state, you will not be able to get a license under our framework that we're putting together here. So it doesn't just apply to Georgia's law. This would apply to any conviction that you have had in other 50 states. Although we may consider it a felony under Georgia law, other states may consider that particular action a misdemeanor, and that would be the reason I would oppose the gentleman's Second Amendment to make sure that we're addressing that, which there are provisions in the code dealing with other substances where you do get charged with a misdemeanor, and I'd be happy to visit with the senator from the 5th about that. So I would ask for your favorable consideration on House Bill 213. I would ask you oppose Amendment number 1 and Amendment number 2, and I would be happy to yield to any questions, Mr. President.
Chair recognizes the senator from the 53rd for a question.
Thank you, Mr. President. Senator Yield.
I will yield to the distinguished rules chairman.
Well, looky here. Let me ask you that hemp has more redeeming qualities than just medically. Is that correct?
That would be correct to the distinguished
Isn't
rules
it also
chairman.
true that you can actually make rope out of hemp?
You can make rope out of hemp.
Okay, thank you. I appreciate this
The
bill,
gentleman knows
too.
of which he speaks. Thank you, sir.
Chair recognizes the senator from the 12th for a question.
Thank you, Mr. President. Will the gentleman in the well yield?
I'll yield to my good friend from Southwest Georgia.
Thank you. Senator, isn't it true that because of all the devastation that our farmers in Southwest Georgia have suffered, this becomes a secondary or product for them to produce and
Yes, ma'am.
hopefully give them some additional needed revenue
It would.
for
It
the family farms?
It would be very beneficial to our farmers down in Southwest Georgia. That
Thank
have,
you.
Yes,
Thank you
ma'am.
so much.
Thank you. And very beneficial to Fort Valley State. to
Chair
the-
recognizes the senator from the 28th for a question.
Thank you, Mr. President. Does the senator yield?
I'll yield.
Senator, can you explain to me, does hemp have THC in it at any level?
No more than 0.3%.
0.03%?
0.3%.
0.3%. Okay. So it's off the schedule completely after the farm bill.
Federal
correct?
law has removed it from the schedule completely.
Okay. And is THC still in Schedule 1 on the Control Substance Act?
I know that I would defer to the gentleman's knowledge, but I would, without seeing the schedule, I would presume that anything over 0.3% would continue to be on the scheduled list. Yes.
Okay. So, but is
Which would be considered
THC
marijuana.
Is THC that's on Schedule 1, is it defined as a percentage that you're aware of?
I'm not aware of that, Senator.
So would you say if hemp that has a percentage of THC in it, but yet THC is in Schedule 1, would you now say that maybe federal law is in conflict with federal law?
I would have to research that, my good friend. I don't know the answer to that question.
Fair enough. Well, I appreciate your work on this bill. It's a good bill.
Thank you.
Chair recognizes the senator from the 51st for a question.
Will you yield?
I'll yield.
This morning we talked about a fee that's in this bill on line 112, and you gave a good explanation on it.
Yes.
Could you tell the chamber what
I'll
your
be,
answer was?
I'll be happy to do that. As this bill passed the House, there was a set fee for individuals who wanted to grow hemp in our state in Ag Committee, and I want to appreciate the good work of the chairman of the Ag Committee as well as other members of the Ag Committee who worked diligently on this legislation to get it to where it is now. We decided that a per acre charge would be the fairest way to do this because in a lot of cases you may only be growing 5 or 10 acres of hemp. And in that particular instance, you should not be charged with the higher fee to be able to grow hemp. So it would only be based on a per acre basis, which in turn would give a lower permit fee for those who are growing smaller acres, and those who grow larger acres would have the higher fee.
Chair recognizes the senator from the 31st for a question.
Thank you, Mr. President. Senator, yield.
I'll yield.
This 0.3% limit that's in the bill, is that 0.3% of any part of the plant, or is that the whole plant?
My understanding is it would be 0.3% derived from the entire plant.
So would it be true if someone picked the buds off of a plant that they could be much higher in THC while the base of the plant doesn't have much THC, and you might meet the 0.3% by averaging it all together?
That is a good question, Senator. I think that it is, and there are specifics in the bill of what, and I would direct you to that if I can find it really quick, of what specifically they will be testing. And in that event, the individuals that would test the product obviously would have to determine whether or not it's above or below the 0.3%. So depending upon what part of the plant they're actually testing, it would affect, obviously, as you're indicating, it could possibly affect the 0.3%. Yes.
I don't have any experience in this, but I've heard it's the buds that people that like to get high tend to smoke the buds and not the whole plant. Have you heard that?
I have, but I will tell the good senator, based on the knowledge that we have of hemp being grown in other states, and based on the knowledge that we have in regards to this issue, based on what the research that has been done, not in our state but in other states, that to get high off of hemp, which is 0.3% or less, you would have to have an entire truckload. And to the good senator, that would be a big old roll, if you know what I mean.
I think I do. I had a question about that roll. You yield for
I yield.
Additional questions? So I think about a roll of hay. You've seen them in South
Yes,
Georgia.
sir.
Hay baler goes through there and rolls up this bale of hay, and maybe 5 foot tall, 4 foot wide. Some of them's larger than that, but a 4x5 roll can easily weigh 1,000 pounds. If someone had a roll of hemp like that, how many pounds of THC would be in a 1,000-pound pile of hemp?
Well, you would have to do 1,000 times 0.3, which would leave you with.
I understand, Senator, you're not good
Whatever
at
that
math,
is.
but if I could help you out, it might be 3 pounds.
3 pounds. There you go.
I think 3 pounds of pure THC is probably enough to get to city high, right?
I'll defer to the senator's knowledge on that.
Thank you, Senator.
All right, Senator, you have a number of questions. Do you continue to yield?
I'll be happy to. Mr. President, I know it's been a long day already. I'd appreciate this body's support on the underlying legislation, no to the amendments, and I will yield the well.
Senator has yielded the well. The chair recognizes the senator from the 48th to speak to amendment number 1.
Thank you, Mr. President. I wanted to share with this body that I did sit on the committee as to this bill, and as a former prosecutor, I did ask questions about how this was going to be monitored to make sure that it would not become above the 0.3 amount. And if it is if the land is tested, which it will be tested, if it's above the 0.3 amount, to a 0.35, I think, it will be retested, 0.33. It'll be retested, and if it's above that, it will be destroyed. So there are mechanisms within this to keep the bill within what I consider appropriate guidelines from my experience as a prosecutor. As to the First Amendment, much has been made about having this be an open market, and therefore, to keep it an open market to allow not only farmers, but anyone who might want to get into this business and have a free and open market, you would need to strike the wording on lines 114 through 115, which states, shall be a qualified agricultural producer as defined in Code Section 48-8-3.3. And if we strike those words, this is a true free market. And if we want to have a true free market with opportunity for all of the people of Georgia, we should strike those lines and make it be so. If there are no questions, I'll yield the well.
You have no questions.
Thank you, sir.
Chair recognizes the senator from the 5th to speak to his amendment, amendment number 2.
Thank you, Mr. President. Dear Senator, I'm not a lawyer, but you don't have to be a lawyer when you're a legislator. You get a lot of lawyers' friends around. So I also sit in the Agriculture Committee. When I was looking at the bill, it looked like there's no, I mean, as far as I know, the lawyer friend that I asked, in Georgia, trafficking or selling is automatically felony. It's not a misdemeanor. And in terms of we're trying to, do a criminal justice reform, and I think this word is misleading over here, misdemeanor. You know, if you are trafficking or selling, is automatically felony in Georgia. So I don't think we need that misdemeanor word in there. Thank you.
You have no questions. All right, let's take up the amendments. We'll start with amendment number 1. The question is on the adoption of amendment number 1. Is there objection to the adoption of the amendment? There is objection. All those in favor of the amendment from the senator from the 48th will vote yea, opposed nay. The secretary will unlock the machine on amendment number 1. For what purpose does the senator from the 27th rise?
Mr. President, I ask unanimous consent to be excused from voting on HB 213 pursuant to Senate Rule 5-1.8D.
Senator from the 27th, is there objection? Hearing no objections, you're excused. State your inquiry.
Mr. President, isn't it true if you vote yes for this amendment, you're creating a free market for all the people of Georgia to be able to engage in this agriculture?
Each and every member can make that decision. On the adoption of the amendment, the yeas are 22, the nays are 31, and the amendment is lost. All right, now we'll take up amendment number 2. Amendment number 2, is there objection? Wait your turn. There's objection. All those in favor of the amendment from the senator from the 5th will vote yea, opposed nay. The secretary will unlock the machine. On the adoption of the amendment, the yeas are 21, the nays are 32, and the amendment is lost. All right, the question now is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none, and the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? Chair hears none, and the question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor vote yea, opposed nay. The secretary will unlock the machine. For what purpose does the Senator from the 24th rise?
Mr. President, is it not true that this is the hemp bill, not the Kemp bill?
Is this a parliamentary inquiry?
Is it not true that
Is this parliamentary inquiry?
Parliamentary.
State your inquiry.
Is this not true? This is the hemp bill, not the Kemp bill.
On the passage of the bill, the yeas are 45, the nays are 6. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Once again, Mr. Secretary, I've been looking forward to this for a while. Can you read the caption of House Bill 253?
House Bill 253 by Representatives Hawkins of the 27th and others. A bill will be titled enactment Title 43 of the OCGA relating to professions and businesses so as to update and revise various provisions relating to occupational therapists and for other purposes. Mr. President, that concludes the order.
Chair recognizes the Senator from the 32nd to speak to House Bill 253.
Thank you, Mr. President. I think this bill really is not controversial, I hope. As a hand surgeon, I've worked with occupational therapists my whole career, and I'd like to take this opportunity to publicly thank them for their help over my 30 years of hand surgery. This bill updates the code section regarding licensure of occupational therapists, which has not been updated in over 20 years. The bill does not change the scope of practice of OTs. It incorporates telehealth language and updates treatment terminology. It also strengthens the disciplinary and educational portions of the code section. This bill has been vetted with other healthcare groups. There's no known opposition, and I would ask for your favorable consideration. Happy to answer any questions.
Senator, you have no questions.
Thank you.
Does any other senator wish to speak for or against the bill? The chair hears none. The previous question is ordered. Is there objection to agreeing to the committee report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor vote yea, opposed nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 51, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, can you read the caption of House Bill 315?
House Bill 315 by Representatives Newton, the 123rd, and others. Bill will be titled enactment Article 1 of Chapter 8 of Title 36 of the OCGA relating to general provisions applicable to counties, municipal corporations, and other governmental entities, so as to provide for certain agreements from consultants who enter into contracts or arrangements with counties, municipalities, or other governmental entities to prepare or develop specifications or requirements for bids, requests, or proposals, procurement orders, or purchasing orders, and for other purposes. Mr. President, Senate Government Oversight Committee offers following subject to House Bill 315, bill be titled enactment, Article 1 of Chapter 8, Title 36 of the OCGA, relating to general provisions applicable to counties, municipal corporations, and other governmental entities, so as to provide for certain agreements from consultants who enter into contracts or arrangements with counties, municipalities, and other local governmental entities to prepare or develop specifications or requirements for bids, requests for proposals, procurement orders, or purchasing orders, and for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 24th to speak to House Bill 315.
Thank you, Mr. President. This is a very simple bill. All this bill does is that it requires a consultant who's providing the service to a city or a county to disclose the financial or material relationship with any of the bidders that would reasonably be expected to create a conflict of interest. I consider you vote green on this bill. No question.
You have no question, Senator. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? Chair hears none. The main question is ordered. Shall this bill now pass by substitute? The questions on the passage of the bill by substitute. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 52, the nays are 0. This bill having received the requisite constitutional majority is therefore passed by substitute. For what purpose does the senator from the 28th rise?
Mr. President, I ask for unanimous consent that the rules be suspended to allow SR 458 to be first read and referred to committee.
Senator from the 28th has asked that Senate Resolution 458 be read for the first time. Is there objection? No objection. Mr. Secretary, will you read the caption?
Senate Resolution 458 by Senator Brass of the 28th, a resolution honoring the life of Mr. Jimmy Lassiter and dedicating a road in his memory and for other purposes.
The chair will assign that Senate Resolution 458 to Transportation. Mr. Secretary, will you read the caption of House Bill 344?
House Bill 344 by Representative Gamble of the 15th and others, a bill will be titled enactment Chapter 8 of Title 40 of the OCGA, relating to sales and use taxes, so as to provide that the mission to advance arts in the state shall not be required to be an organization's primary mission in order to obtain an exemption for certain sales of tickets, fees, or charges for admission to fine arts performances or exhibitions and for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 14th to speak to House Bill 344.
Thank you, Mr. Chairman. This is a simple bill. We call this a Habitat for Humanity bill. Back during the recession, many people donated property to the Habitat for Humanity. When they sat on this, they were paying property tax. This is a property tax exemption. What would happen is once the property is built out, then they would capture that property tax on that. In the event that the property is ever sold, prior to something being built on it, there would be a clawback provision. If there are no questions, I'll yield the well.
You have a question. Senator, Chair recognizes the Senator from the 48th for a question.
Thank you, Mr. President. Does the chairman yield?
I will.
Do we have a fiscal note for House Bill 344?
My good friend from the 48th, this is coming from the House. Do you really expect they would do the proper thing and get us a fiscal note?
You have no more questions.
Thank you.
Does any other senator wish to speak for or against the bill? Chair hears none. The previous questions ordered. Is there objection or agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. And the report of the committee is agreed to. Shall the main question be now put? Are there any objections? Chair hears none. The main question is ordered. Shall this bill now pass? The questions on the passage of the bill. All those in favor will vote yea. Opposed, nay. The Secretary will unlock the machine. On the passage of the bill, the yeas are 54, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, can you read the caption of House Bill 346?
House Bill 346 by Representative Cooper, the 43rd, and others. A bill will be titled Enactment Article 1 of Chapter 7, Title 44 of the OCGA relating to landlord and tenant generally, so as to prohibit retaliation by a landlord against a tenant for taking certain actions, provide for circumstances that are not considered retaliation for other purposes. Mr. President, Senate Committee on Judiciary offers the following subject to House Bill 346. The bill will be titled Enactment Article 1 of Chapter 7, Title 44 of the OCGA relating to landlord and tenant generally, so as to prohibit retaliation by a landlord against a tenant for taking certain actions and for other purposes. Amendment 1 by Senator Stone of the 23rd offers the following amendment. Amendment 1 to amend the Senate Committee substitute to House Bill 346 by inserting the word rebuttable and for other purposes. Mr. President, that concludes the order.
For what purpose does the Senator from the 23rd rise?
Mr. President, I move the Senate table House Bill 346.
Senator from the 23rd has moved that the Senate table House Bill 346. Is there objection? No objection? And House Bill 346 is placed on the table. Mr. Secretary, can you read the caption of House Bill 373?
House Bill 373 by Representative Werkheiser, 157th, and others. Bill will be titled Enactment Title 34 of the OCGA relating to labor and industrial relations, so as to change certain provisions relating to the Department of Labor and Employment Security, so to authorize the Commissioner of Labor to perform certain functions, prescribe certain rules and regulations for other purposes. Mr. President, Senate Committee on Insurance and Labor offers the following subject to House Bill 373. The bill will be titled Enactment Title 34 of the OCGA relating to labor and industrial relations, so as to change certain provisions relating to the Department of Labor and to Employment Security, to authorize the Commission of and for other purposes. Mr. President, that concludes the order.
Chair recognizes the Senator from the 20th to speak to House Bill 373.
Thank you, Mr. President. Good afternoon. House Bill 373 is a Georgia Department of Labor bill. Most of it, or a lot of it, deals with the annual update on the weekly benefit amount that an unemployed person would get. We have not changed that, I think, since 2008. It also gives the commissioner the authority to do criminal background checks, and we need to have that so that they can access the federal IRS information. They have to do this thorough criminal background checks of their employee. Make some other minor changes. The effective date of when claims would begin, they would all begin on a Sunday. And the biggest thing it really does is moves the Workforce Development Council back to the Department of Labor. It's currently under the Technical College System of Georgia. Ask for your favorable consideration. Be glad to answer any questions if I can. If not, I will yield the well.
Senator, you have you actually have a question. Chair recognizes Senator from the 38th.
Thank you, Mr. President. Can you tell me what the rate is going up to now since we are changing it from 08?
The increase in the weekly amount of wage benefits, the maximum will go from $330 to $365 a week, the maximum. The minimum will go from $44 a week to $55 a week.
Okay. There was one other question, but I'm going to let it go since I was out trying to grab some food, and I'm not thinking of it right now.
All right.
Thank you.
Thank
you have no more questions, Senator.
Thank you.
Any other
Appreciate it.
senators wish to speak for or against the bill? The chair hears none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? Chair hears none. The main question is ordered. Shall this bill now pass by substitute? The question's on the passage of the bill by substitute. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 53, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Mr. Secretary, can you read the caption of House Bill 392?
House Bill 392 by Representative Widower of the 119th and others, a bill entitled Enactment Code Section 45.721 of the OCGA, relating to expense allowance and travel cost reimbursement for members of certain boards and commissions, so as to provide expense allowance and travel cost reimbursement for members of the Board of Public Safety, in like fashion as other state boards and commissions and for other purposes. Mr. President, Amendment 1 by Senator Harper the 7th and others offers the following amendment. Amend House Bill 392 by replacing lines 1 through 4 with the following. To amend Title 45 of the OCGA relating to public officers and employees to provide expense allowance and travel cost reimbursement for members of the Board of Public Safety to revise duties of the Secretary of State and for other purposes. Mr. President, that concludes the order.
Chair recognizes Senator from the 7th to speak to House Bill 392 and his amendment number 1.
Thank you, Mr. President. Ladies and gentlemen of the Senate, underlying House Bill 392 simply adds members of the Board of Public Safety to the list of individuals that can receive expense reimbursements and travel reimbursements, such as many of the other members of the boards and commissions across our state. The amendment that you see before you deals with an issue relating to the security of voting systems in our state. It's a request of the Secretary of State's office and also has been approved by Common Cause. So they have come to an agreement on the language that you see on your desk. It's a good framework to allow the Secretary to use in establishing security requirements for voter information. And it's just to trying to address an issue that we need in regards to securing our election system in our state. And if there are no questions, Mr. President, I yield the well and ask favorable consideration on both.
You have no questions. Does any other senator wish to speak to the bill or the amendment? Chair hears none, and we will take up amendment number 1. The question is on the adoption of amendment number 1. Is there objection to the adoption of the amendment? Chair hears none, and the floor amendment is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass as amended? The questions on the passage of the bill as amended. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 55, the nays are 0. This bill having received the requisite constitutional majority is therefore passed as amended. Rounding third base here. Mr. Secretary, will you read House Bill 459?
House Bill 459 by Representative Earhart of the 36th and others, a bill we titled enactment Part 5 of Article 22 of Chapter 2 of Title 20 of the OCGA, ruling the school buses so to provide for a driver's license verification system for school bus drivers and for other purposes. Mr. President, Senate Public Safety Committee offers the following substitute to House Bill 459. Bill will be titled enactment Part 5 of Article 22, Chapter 2 of Title 20 of the OCGA, ruling school buses so to provide for a driver's license verification system for school bus drivers, require participation by local boards of education, provide for data submission, provide for rules and regulations, provide for coordination among the Department of Public Safety, the Georgia Technology Authority, and the Department of Driver Services, and for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 56th to speak to House Bill 459.
Thank you, Mr. President. House Bill 459 does two things specifically. The first thing, in working in conjunction with our Department of Public Safety and our esteemed Public Safety Commissioner, Colonel Mark McDonough, has us twice a year check the status of commercial driver's license of our school bus drivers. Today, when they are hired, this check is done, but it is not done subsequently. In this new process, they will submit each school board the list of the drivers' names and their license numbers, and they will check those on a periodic basis to make sure that they haven't had their licenses suspended for any reason. Second part of the bill, again fairly simple, allows law enforcement to use civilian law enforcement who have passed a post-certified training class to help out with things such as traffic control. You may know them in your community as CERT officers or Community Action Police CAPS officers who you'll see sometimes at events helping to direct traffic or to help out in certain areas when our regular law enforcement officers are being used for upholding other lawful items. If there are no questions, I will yield the will.
You have a couple of questions. Chair recognizes the senator from the 34th for a question.
Will the chairman yield?
Absolutely.
How old are these civilian officers?
They have to be a minimum of 18 years old, but a lot of folks are doing it actually after they retire. So in my community, where I serve as a firefighter in Alpharetta, we have what's called the CAPS officers as well as the CERT program. Most of those are retired folks that are wanting to help out in the community that will go through this training and help out.
But at least 18?
That is correct.
Thank you so much.
Chair recognizes the senator from the 38th for a question.
Thank you, Mr. President. Will the senator yield?
Certainly.
I thank you for bringing this bill, but I'm looking at it and you mentioned that they're going to have to immediately send an okay, and the board is responsible for doing this twice a year. What mechanism will the board be using? Are you prescribing a certain mechanism that they will be using to verify the license and to get the, or who's going to verify and get the information to the board, I guess is what I'm
that's a great question, Senator. What they will do is the school board will assemble a list of the names and their corresponding driver's license. That will be submitted to the Department of Public Safety. They will then run that check, and if anything comes back flagged, they will then return it to that school system to let them know what the challenge is.
Thank you very much.
Thank you.
You have no more questions.
Thank you. I urge your favorable consideration on this very important bill.
Any other senator wish to speak for or against the bill? Chair hears none, and the question is now on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Shall the main question be now put? Is there any objections? The chair hears none. The main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 55, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. What purpose does the senator from the 7th rise?
Mr. President, I ask unanimous consent that the Senate immediately transmit House Bill 392 to the House.
Senator from the 7th has moved that the Senate immediately transmit House Bill 392 to the House. Is there objection? No objection, and House Bill 392 is immediately transmitted. Mr. Secretary, can you read the caption of House Bill 493?
House Bill 493 by Representative Tanner of the 9th and others. A bill we titled enactment in Chapter 2, Title 8 of the OCGA, relating to standards, requirements for construction, alteration, etc. of buildings and other structures, so as to provide procedures for alternative plan review, permitting, and inspection by private providers, so as to simplify regulations on business at the local level and for other purposes. Mr. President, Senate Committee on Regulated Industries and Utilities offers the following substitute to House Bill 493. Bill will be titled an act to provide for professional engineers or other professionals to review certain plans related to building development if certain conditions are met, so as to provide for a determination in a timely manner to amend in Chapter 2 of Title 8 of the OCGA, relating standards, requirements for construction, alteration, etc., for other purposes. Mr. President, that concludes the order.
Chair recognizes the Majority Leader to speak to House Bill 493.
Thank you, Mr. President. I'm glad we got this last bill on the floor in front of us. For those of y'all that have been here for a minute, you'll remember a couple of years ago we had a bill called Senate Bill 2 come through, and it created efficiencies within the permitting and review process. You also remember that it passed unanimously out of this body. We're all for it. Unfortunately, it went to the House side and sat for a second or 2 years. Now, Senate Bill 2 did eventually pass, but none of the language we had in there, nor the title that we had on Senate Bill 2 was still included. The only thing that passed was the title Senate Bill 2. Fortunately, the House members that spent 2 years being against the bill are now adamantly for it. So what I bring before you is a streamlining process that shortens the time within a government authority has to perform a plan review from 6 weeks to 4 weeks, allows owners to go straight to a private market regardless of whether the governing authority can provide the service. Previously, they could only do that if the governing authority could not. The legislation also doubles the liability insurance at private plan reviewers to $1 million per claim for any project with a construction cost of $5 million or less, or $2 million for any claim with a construction cost of $5 million and more. Now, if the local convening authority can do the review and the agency or the entity still wants to go to a private agency to do it, they pay the local governing authority 50% of what they would have paid on the price to start with. Now, so why would they do this? As the permitting needs and requirements go up and down, a lot of the municipalities don't have the time to do it. So this is during high demand areas is when this would be most plausible. And this has no fiscal impact on either local governing authorities or the state. Subject to your questions. Thank you. I yield the well.
You have no questions. Any other senators wish to speak for or against the bill? The chair hears none, and the question is on the adoption of the committee substitute. Is there objection to the adoption of the committee's substitute? Chair hears none. The committee's substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? Chair hears none. The main question is ordered. Shall this bill now pass by substitute? The questions on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 54, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair would like to recognize the majority leader for a motion.
Sorry, Mr. President, I was still basking in that vote. I move that the Senate stand adjourned until 10 o'clock on Thursday, March 28th.
Mr. Secretary, any announcements?
Rules will meet upon adjournment in 450 of the Capitol. Regulated industries and utilities will meet up in 450 of the Capitol upon adjournment of rules. Agriculture and consumer affairs will meet in Mez 1 and, at 4 p.m. and transportation will meet at 4 p.m. in 310 of the CLB. Mr. President, that concludes the order.
Chair recognizes the senator from the 31st to make an announcement.
Thank you, Mr. President. Members of the Senate, we're down to 2 days left for you to participate this year in our Legislative Prayer Fellowship. I think if you have talked to your seatmates, many of you have been there. The Senate has had great participation. And Thursday morning, our president is going to bring our devotion for us, so I would encourage you all to attend if you can. That will be at 7:15 a.m. in the 107 of the Capitol. Thank you.
Thank you, Senator. Looking forward to it. Any other announcements? The majority leader has moved that the Senate stand adjourned until 10 a.m. on Thursday, March 28, 2019. All those in favor of the motion signify by saying aye. Opposed, no? The ayes clearly have it, and the Senate stands adjourned. Great work today.